Are you allowed to use somebody else's photo in your content if you're referencing something that they created? Let's talk to a lawyer to find out.
My name is Tony Leocastis. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
We get a really interesting question this week on the YouTube channel about whether or not it is legal to use someone else's photo on your blog or your social media if you're linking that post to the photo. Specifically, the example that they gave was, can they show a crochet pattern photo if that's what they are creating and then use that Etsy listing photo and link back to it? Is this something that is going to be copyright infringement, or is this something we can actually do?
So it's a very interesting question to be asked because, ironically enough, a few years ago, I would have said, no, this wouldn't have been copyright infringement because of a little known rule called the server test, which was a test that came out of the Ninth Circuit over in the West Coast that essentially ruled that if you're, let's say, hyperlinking or let's say embedding a post that belongs to somebody else in your website, but the whole purpose of you embedding it is, like in the example you're sharing, to like show off, let's say, someone else's origin product, and your hyperlink would direct the user to actually the actual website where it's featured. That is just something that is no different than if, let's say, I embedded an Instagram video or Instagram photo on my blog or on a website, because I'm not actively pulling the material and hosting it on my server, on my website. And so the Ninth Circuit created a server test where if you're just showing the material instead of actually housing and storing the data, that's not enough to qualify as copyright infringement. You're not acting as a server. But if you are storing the material, storing the data, and you're simultaneously showing it, that's where you are would qualify for copyright infringement. Now, as I said a little bit in my little mini prologue there, I would have said a different answer a few years ago. Today, that rule has changed entirely. The Second Circuit Court of Appeals has ruled, actually, I should take that back, Southern District of New York, has ruled that the server test is no longer good law. So they have now modified it where even when you embed something, it is expected that you would get permission from the copyright owner in order to include it on a website. And bottom line is the rationale from the court was that the server test is just incomplete law. It's not very clear on, basically laying out kind of like the parameters of what is or isn't copyright infringement. I guess it's kind of like a East Coast, West Coast kind of battle from what I read in the legal decision. But the Southern District of New York decision, which if anybody's interested, is the Nicklin versus Sinclair case. That was a case about a media company called Sinclair Broadcasting embedding an Instagram video of this emaciated polar bear that belonged to this videographer named Nicklin. I don't know what his first name is, but the embedding of that video on Sinclair's website and all their affiliate websites was enough for the court to say server test does not apply. You're still using someone else's copyrighted work to put on your website. Mm-hmm. And I guess the other thing that's unique here is that even on that caption of Nicklin's video, it does say for use of this video, contact X agency. So it did include information about licensing the video for some type of use like on news. So I think that also added a bit of a unique wrinkle to this whole fact pattern. But nonetheless, the main takeaway here is that the server test is no longer good law. So if you are the type of person that likes to hyperlink things, especially on your website, I think it's just a good precaution to, especially if you're talking about someone else's copyrighted work, like you're hyperlinking a photo or a video and you're actually showing it on your website. I think it's good practice, especially in light of the Nicklin versus Sinclair case, to contact the original copyright owner, just ask for permission if you can showcase a preview of their copyrighted work. And if they expect a license fee, then either your choice to pay up or not. But if they give it to you gratis, then great. You have the ability to showcase it on your website, but at least you did it right by asking for permission.
And of course, it's always important to remember that you are going directly to the source. So if you are doing something like pulling a product off of Etsy or Amazon or some other location, you're not necessarily going to Etsy to ask for permission. You are going to the creator of that content to get their feedback on whether or not you can be doing that. Always make sure that you are safe rather than sorry, and get that permission first rather than asking for forgiveness later on, because that could end up with a potential lawsuit for you. So don't do that. And of course, if you got questions, go ahead and drop those down below for us. And as always, you can reach out to Tony on his social medias, where he's keeping us legally protected in the entertainment and IP space. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can follow my podcast, End Scene, and Entertainment Law Podcast, every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
If you have questions to keep you legally protecting the entrepreneur space, drop those down below. Tony's coming back for upcoming episodes, and we're dropping daily videos to help you navigate the world of social media so you can make content easier and faster with less stress, but make more money from the content you're creating. We'll see you in the upcoming episodes.